Hello and welcome to Topic 11, Lecture 2 on Evidence and Investigation. And in this lecture, we're going to look at key cases. So what are we going to be covering in this lecture? Well, we are going to look at the case law and the court's evolving definition of what constitutes a search. Then we're going to take a look at the times when you don't need a warrant, but that it's still legal to search. And so we're going to look at exceptions to the warrant requirement. And I just want to point out that there's a lot of material in this chapter, so make sure that you read the course commentary. And if you have any questions about the cases that we didn't discuss in lecture, feel free to reach out to me. We can set up a Zoom meeting, or you can send me an email or a text. Okay, let's get started. The Fourth Amendment applies only to searches and seizures. If a government action is not considered a search, or if a government action is not considered a seizure, the Fourth Amendment is not triggered. It doesn't apply to that action. And we used an example of that in the last lecture. We talked about how the word search has been interpreted by the courts to apply to the actions of government, a governmental search, or in other words, a police search. And so that if a private person engages in a search, by common parlance, it would be considered a search. However, the way the word search is used in the Fourth Amendment, it must apply to the actions of a governmental action. So if your employer searches your desk at work, it really doesn't trigger the Fourth Amendment. However, if a police officer searches your desk at work, it does trigger the Fourth Amendment. And so it's the court that defines what constitutes a search. It's the court that also tells us not only what is a search, but whether a search is reasonable. And so we're going to take a look at three important cases that help us understand the way that the court has defined what constitutes a search and how the definition of search has evolved over time. So the cases that we're going to look at start in 1929, and so we'll be taking a look at Olmstead versus the United States. And the question that comes about in this case is does a search need to be a physical intrusion or a trespass? So if a physical intrusion or a trespass doesn't take place, does that mean that it's not a search? Then we're going to move to Katz versus the United States in 1967. And the question in Katz is about whether an intrusion into a private place that isn't a physical intrusion, is that a search? And then finally, the case that we're going to take a look at is United States v. Jones from 2012. And in this case, the question before the court is, does Katz replace does Katz replace Olmstead or supplement Olmstead? Okay, so right now that stuff might not make sense, but it will make sense as we go through these three cases. So let's go ahead and take a look at these cases. Okay, so one of the first cases that the Supreme Court hears about the Fourth Amendment is a case called Weeks versus the United States, and it's from 1914. And in this case, the court ruled that illegal seizures of items from a private home violate the Fourth Amendment. This is a case about a guy, his name is Fremont Weeks, and he was involved in the transportation of lottery tickets, illegal lottery tickets, through the United States mail. And that was a violation of federal law. And so federal agents thought that he was involved in this illegal activity. And so they came to his house. They didn't have a warrant. They entered into his house and they seized papers which linked him to the crime of transporting lottery tickets through the mail. Now, this was done without a search warrant, and Freeman Weeks basically said that his Fourth Amendment rights had been violated, and the court agreed. Weeks is an important case because it tells us that the court says that a physical trespass or a physical intrusion into a person's home constitutes a search. And that should not be surprising because the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. So entering into somebody's house to search clearly is a search. Question is whether or not it violates the Fourth Amendment, and they said that that it did violate the Fourth Amendment because law enforcement, they had no search warrant, which means that they likely did not have probable cause. They just entered in old school, took stuff, used it to charge him with the crime, charge and convict him with the crime. And so this is an important case because it tells us what a search is, a physical intrusion into your house. But it also is really important because it establishes this doctrine that's known as the exclusionary rule. And so that in the United States, that if police collect evidence, seize evidence, and that the seizure of that evidence is a product of an illegal search, which it was in the case of Weeks, because the law enforcement did not have a warrant, what the seized items cannot be used in court. They're inadmissible in court. And that is what's known as the exclusionary rule. It's kind of basically we're putting a constraint on government, telling them that they can't engage in unreasonable searches. But we're also saying if you do that, then you can't use what you found in a criminal conviction. So it actually puts a little bit of teeth behind the provision of that you can't engage in an unreasonable search. If you could engage in an unreasonable search and use that evidence, well, then cops would more likely engage in unreasonable searches. And so Weeks is important because it establishes the exclusionary rule. Now, this brings us to the case of the three cases that I listed at the start of the lecture, which is Olmstead versus the United States. And so Olmstead addresses the question of whether a search as used in the Fourth Amendment only applies to physical intrusions into your house. Or are there other types of intrusions, like listening into what's going on in your house? Does that actually constitute a search? So let's look at the case Olmstead. So what is the case Olmstead versus the United States about? Well, Olmstead, see the date there, 1929. It is a case that is a product of the prohibition of alcohol in the United States. And so this case is about a bootlegger. And the bootlegger's name, he's pictured there, is Roy Olmstead. And I think a lot of times when we think about the prohibition crime era, we think about people like gangsters like Al Capone. But Roy Olmstead was probably one of the best and most famous rum runners, people who brought in alcohol into the United States during the time of Prohibition. But, most of us don't know who Roy Olmstead is, although we do now because you're taking a civil liberties class. But he's probably one of the most famous, Prohibition criminals at this time period. So let me tell you a little bit about Roy Olmstead. Roy Olmstead was involved in bringing in alcohol from Canada. And so he lived in Seattle. And in fact, he was a lieutenant of the Seattle police force. And so as a member of the police force, he was involved in the illicit activity of bringing whiskey in from Canada into Seattle, into the United States. And that as a member of the police force, he got busted for doing that and he got kicked off of the police force. Okay, so like in the great American tradition of cops doing bad things and then getting busted and then continuing on in their bad ways. And so, historians say that, that getting busted for being a bootlegger as a lieutenant in the police department is really a good thing for Roy Olmstead because he could really focus all of his activities on bootlegging. And that's what he did. And he was known as being a good bootlegger. The alcohol that he brought in from Canada, he didn't cut with water. He didn't cut it with chemicals that would make people sick. I mean, like when you bought rum or whiskey from him, it was going to be the good stuff. Okay. And so he also was, since he was former police, involved with the police department, he knew a lot of people. He knew the mayor, and a lot of people kind of looked the other way. Well, I'll tell you who didn't look the other way was the federal government. And so the federal government knew that Roy Olmstead was violating the laws prohibiting the importation and production of alcohol in the United States. And so they started investigating him. And as a part of the investigation, that they placed wiretaps on his phone lines, okay? And so they placed a tap on the phone lines that he used at his office. And so he had an office that was a part of his bootlegging endeavors. And so that they went into that office building and that they placed a tap on his phone there. And then they also placed a tap on his phone line at his house. However, they didn't enter in to his any private place, at his place at his office. He didn't own the office building. It was privately owned, and that they got the permission to go in and put that tap on the phone at this office that he worked at. And for the tap on his phone at his house, they didn't enter into his home. They didn't like break in and put like a microphone on his phone. They actually put a listening device on the telephone line that was outside of his house. So there was no actual physical intrusion into his house. They used the information that they got from these phone lines. They didn't have warrants for the phone lines. They didn't feel like they needed these warrants because they felt as if they weren't intruding into his house, into his private place. And so they didn't feel like they needed warrants. And so they collected the information from the phone tap, and then they used that to get a warrant to arrest and then to convict. And Roy Olmstead cried foul. He basically said that the police had violated his Fourth Amendment rights to be free from an unreasonable search and seizure. So let's see what the question before the court is. So what was the question before the court in Olmstead? The question was, did the use of evidence disclosed in wiretapped private telephone conversations violate the Fourth and the Fifth Amendment? And we've been talking about this case as it relates to the Fourth Amendment, but it also relates to the Fifth Amendment as well. One of the things that Roy Olmstead's lawyers argued was that that basically he was sort of coerced into incriminating himself, right? Because that they were listening into his conversations, and therefore he was, incriminating himself, and that because the government took that information without him knowing, that it was a violation of the Fifth Amendment. But we're really learning about this case also mostly because of the Fourth Amendment and the way that the government defined search. But I just wanted to add that in there since it was a case about the Fourth and the Fifth. And in a very close decision that they said on both counts, that using evidence from a wiretap, it does not violate the Fourth, and it doesn't violate the Fifth Amendment either. They said it didn't violate the Fifth Amendment because nobody was forcing Olmstead to have conversations on the phone, those were voluntary conversations that were listened into. But most importantly, they said that the Fourth wasn't violated because there was no physical intrusion into Roy Olmstead's house. And therefore, a search had not taken place. The Fourth Amendment does not apply. They said that the law enforcement had not trespassed onto Olmstead's property, and that's true. They put the listening device on the telephone wires outside of his house on a public telephone pole. There was no intrusion into Roy Olmstead's place. That the Fourth Amendment doesn't apply to public places like the street and the telephone pole. And so the court says that the Fourth only covers property, physical space, not conversations. So sure, his conversations were intruded on, and that is true, but the Fourth only applies to physical intrusions into physical things, like your property, like your home. Therefore, there was not a search that took place, and since there was no search that took place, the Fourth Amendment just basically doesn't apply. And therefore, what the law enforcement did was constitutional, it was illegal, because they were not constrained by the Fourth Amendment because this was not a search. Make sure you read in the textbook about Brandeis's dissent. And we've actually already touched on Justice Brandeis's dissent because we talked about the role that Olmstead played in the development of a broader concept of the right to privacy. In Olmstead, he dissented. He said that the right to be left alone is fundamental. and that any unjustified intrusion into privacy violates the Fourth Amendment. So Brandeis was basically saying those conversations were private. And even though there was no physical intrusion into his conversation, that's not even like in a way possible because you can't physically intrude into words. He said that still violates the Fourth Amendment because the Fourth Amendment isn't about physical trespassing. It's about this concept of privacy. But that was not the, that was not the perspective that had enough votes, right? 4 agreed with that, but not 5. And so as it stands, Olmstead and the way a search is defined is that it's defined as a physical intrusion into your private space. So the physical intrusion understanding of the word search in the Fourth Amendment lasted for about 4 decades, so about 40 years. And it comes to an end in 1967 with the case Katz versus the United States. And it raises the question about whether a search is more than just a physical intrusion. And so it's sort of a return to the objection that Brandeis raised in his dissent in Weeks. So Katz is a very similar case to Olmstead. It is a case about wiretapping. And so Charles Katz, he is suspected of gambling, not bootlegging, okay? And so, again, gambling is illegal, and he is doing his gambling endeavors between states. And so because it's interstate crime, then it triggers the FBI to investigate. And so they felt that Charles Katz was involved in interstate gambling. And so they, like they did with Weeks, they basically put a wiretap on the outside of a phone booth. And for you youngins here, see, here's my magic pencil. I wasn't exactly sure. Do y'all know what a phone booth is? Because now we don't, we just have cell phones. I'm sure you know what it is. But, a phone booth is a glass booth that has a telephone inside of it. And you put a couple of quarters or however much it costs. I don't even know if we have these anymore. And then you close the door and you go inside and make a telephone call. And so the cops knew that Charles Katz would go to this phone booth in order to use the phone to do his interstate illegal gambling endeavors. And so they didn't have a wiretap. They just put a microphone on the outside of the phone booth. They didn't put it on the phone in the booth. They didn't stick the microphone into the booth. They put it on the outside of the booth. And they didn't get a warrant because they didn't think they needed a warrant because of Weeks. And so, they used the information that they got from this warrantless wiretap to get an 8-count indictment for illegal gambling. And then Charles Katz was charged and convicted. And that, then cried foul, basically saying that his Fourth Amendment rights had been violated. But the government came back and said, well, no, our law enforcement was just following the precedent that had been set in Weeks. And so basically the Supreme Court rehears this sort of case about whether or not the taking of and recording of somebody's conversation violates the Fourth Amendment. So let's see what the question before the court is and how the court rules in Katz. And so the question before the court in Katz versus the United States is a person protected by the Fourth Amendment when he seeks to preserve his privacy even in an area accessible to the public? So keep in mind, Charles Katz went into the phone booth. Charles Katz wasn't having a conversation on a bench in a public park. He went inside of a booth to make a phone call. He pulled the door behind him to basically keep that conversation private. He didn't think he was making a public conversation that could be overheard by law enforcement. He took action to create a private space. And that's why the question before the court is, does that conversation that takes place within that phone booth, is that protected by the Fourth Amendment? And the Supreme Court in the 7-1 decision finds in favor of Katz. And Justice Stewart writes the opinion in the case. They say that this search does trigger the Fourth Amendment. That the Fourth Amendment protects persons, not just places. And so that it's the person that receives the Fourth Amendment protection and the things that that person is doing in a private space. And so the Fourth Amendment doesn't just protect tangible things like homes and papers and personal effects, but that it covers intangible things, the intangible things that people engage in, such as private conversations. And so the change in Katz is that, they say that if there is a reasonable expectation of privacy, cops need a warrant. So clearly inside of a house, there's a reasonable expectation of privacy. Is there a reasonable expectation of privacy in a public phone booth? Yes, it is. The person went in, they closed the door. It's reasonable to think that they were having a private conversation. And if cops want to listen in on that phone call, they need probable cause and a warrant. And so it is reasonable to believe that the conversation in a phone booth is private. Therefore, the cops need a warrant. So Katz is an important case because it expands the definition of what a search means in the Fourth Amendment. Coming out of Katz, it says that if it's reasonable to think something is private, then an unjustified intrusion into this private realm by government agents is illegal or unconstitutional. And so now when thinking about the Fourth Amendment, when you think about a search is an intrusion into one's reasonable expectation of privacy. It doesn't really matter whether or not that intrusion is into your home or into your, into some sort of private physical area, but rather it's where the government's intruding into a place where it's reasonable to think that there is privacy within that place. And the new definition is affirmed in cases that follow after Katz. And let me just put both of these up here because they are interesting cases. And so Kylo v. United States in 2001, and then there's Florida v. Jardines 2013, both referenced in the textbook. Both of these are about cops in trying to investigate people that they think are growing marijuana in their house, okay? And so in Kylo, this is a case where federal agents felt that Kylo was growing pot in his basement, and that when you grow pot indoors, you need to have heat lamps to help with the growing process. And heat lamps can sometimes, not sometimes, but often increase the temperature of the place where the grow lamps are, in this case in Kylo's basement. And so as it stood, the federal agents didn't have enough evidence to get an actual search warrant. They needed more evidence to support probable cause. So one of the things they did was they had a thermal device, and it measured the heat of people's houses on the block. And so they sat outside in their car. They didn't enter into Kylo's property. They didn't walk around the outside of his property, but rather they just stuck the thermal device out their police car, and they took the temperature of Kylo's basement. That was what that thermal device was able to do. And then because his basement was hot compared to the other basements on the block, they used that in combination with other evidence to get a probable cause to search, charge, convict. And Kylo, said that his Fourth Amendment rights had been violated, and the Supreme Court agreed. That they basically said that what is happening into your house is there's a reasonable expectation of privacy. And even though there's no physical intrusion into that private place, that thermal device was basically looking into, technologically looking into your home and taking information. And that if you want to use a thermal device like that, you need to get a warrant to use it. A similar case was in Florida v. Jardines, and that was about Frankie, the drug-sniffing dog. And so in this case, somebody got a Crime Stopper tip that Jardines was growing marijuana in their house. The cops came over, entered the property, which they're able to do. Cops can come to your front door and knock on the door to ask you questions. You don't need a warrant to do that. But they brought Frankie, the drug sniffing dog, with them, and then they weren't just taking Frankie for a walk. They brought the drug sniffing dog for a purpose, and so Frankie snuffed around the front of the house, sniffing in, and then I don't know, his tail started wagging or whatever drug sniffing dogs do, indicating that they smelled marijuana. They used that to get a warrant to search. Again, cried foul. In both of these cases, the Supreme Court said that that's a violation of the Fourth Amendment because it's an intrusion into a person's reasonable expectation of privacy. Another thing I wanted to point out is that the late Justice Antonin Scalia wrote the majority opinion in both Kylo and in Jardines. And so I know that, that a lot of times we think about Scalia as being a conservative justice, but he had a very strong sort of civil libertarian bent, particularly when it came to limitations on police searches. But bottom line is that those two cases reaffirmed what the court said in Katz. So this brings us to the final case we're going to be discussing here, which is United States v. Jones from 2012. And so coming out of Olmstead and then Katz, kind of a question remains. And the question remains is that, does Katz replace Olmstead? And so is searching really only about an intrusion into a place where there's a reasonable expectation of privacy? Or does Katz replace Olmstead, or does Katz add to or augment Olmstead? And so that a physical intrusion into one's home or a physical intrusion into your private property, even if there's not necessarily a reasonable expectation of privacy, is that still a violation of the Fourth Amendment? Or does there really need to be a intrusion into a reasonable expectation of privacy, even if it's so, like the Katz case, it was the phone booth, right? That was a public place, but that there was a reasonable expectation of privacy. Well, what if it's your private property, but there's not really a reasonable expectation of privacy around this piece of private property do you own? Does that mean that the Fourth Amendment doesn't apply to that physical intrusion? And so that question is asked and answered in the case Jones. So let's take a look at the facts of the case on Jones. All right, so United States versus Jones is a case about drug dealing. And it's also a case about putting a GPS tracker on a person's car without a warrant. And so that's Antoine Jones. He ran a nightclub in Washington, D.C., and federal agents felt that he was involved in dealing of cocaine. And so they engaged in some legal surveillance of Mr. Jones, and they did not get enough evidence to get a search warrant. And so they actually got a search warrant to place a GPS tracking device on the undercarriage of Jones's car. I mean, GPS devices usually go on the undercarriage because if you saw it on your car, you would take it off. And so that's a picture of someone putting a GPS device on the undercarriage of a car. So the cops actually got a warrant, but the warrant expired. Bad police work. They put the GPS on the car, on Antoine Jones' cars anyways. There was without a valid warrant. And so then they kept the GPS device on his car for 28 days. They collected a whole bunch of data, and then they used that evidence to get a search warrant. They executed the search warrant. They found drugs, cash, weapons, and then he was charged and convicted and sentenced to life in prison. Katz and his legal team cried foul. They said placing a GPS device on the undercarriage of a car without a search warrant is a violation of the Fourth Amendment. But the United States pushed back, and they said, you know what? There's no reasonable expectation of privacy for your car, particularly on the outside of your car. Cops put boots on your car if you haven't paid your parking tickets. They put parking tickets on your car. And so, cars, it's not really, even though it's private property, it's not really, it's not fair to say that there's a reasonable expectation of privacy for your car, right? And also, cars are on public streets, and, cops can tail cars without a warrant. So how is a GPS different than just tailing a car? It's maybe a more advanced technology, but it's the same. You're following a car on a public street, and there's no reasonable expectation of privacy there. So let's see what the question before the court was and how the court ruled in Jones. So the question before the court in Jones is, does placing a GPS tracking device on an individual's vehicle and using the data from this device constitute a search and seizure under the Fourth Amendment? So in other words, does doing that trigger the Fourth Amendment? And in a unanimous decision, again, the majority decision written by Justice Scalia, again, indicating his strong support for placing limitations on searches, they ruled that yes, placing a GPS device on a person's car does trigger the Fourth. And if you want to use a GPS device, you need to get a warrant. They basically said that the government physically intruded into Antoine Jones' private property. They intruded onto his car. And just because it's a car doesn't mean that it's not private property. For one, a search is a non-physical intrusion into one's reasonable expectation of privacy. Katz, Kylo. But a search is also a physical intrusion into your private property. And placing a GPS on a car is a physical intrusion. And so, therefore, it applies to the Fourth Amendment. The Fourth Amendment is triggered because we know from Weeks that a search is a physical intrusion. So, what's important about Jones is that the question about whether or not Katz replaces or augments Olmstead is that Katz adds to Olmstead. That a search is a place that searching a place where there's a reasonable expectation of privacy, but a search is also a physical intrusion. Katz and Jones tells us what constitutes a search. A search is an intrusion into one's reasonable expectation of privacy, and a search is also a physical trespass on your private property. But what makes a search reasonable or unreasonable? What do you need for a search to be reasonable? Do you need a search warrant for a search to be reasonable? Or are sometimes searches reasonable even if there's not a warrant? And so on the next two slides, we're going to talk about how government can engage in a reasonable search even if they don't have a warrant. And I don't want to spend too much time on this. I just want to do a quick overview of this because you're going to be reading about it more in your textbook. Getting a warrant to search is preferred. It's preferred because, when you get a warrant, law enforcement have presented evidence to sustain probable cause or to demonstrate probable cause. And then a judge signs off on it. And also the warrant, basically says who is going to be arrested or what is going to be searched. But it's not always practical to get a search warrant. Getting a search warrant takes time, and sometimes law enforcement don't have time to get a search warrant, particularly if people's lives are in danger, whether that's people in the community or the law enforcement themselves. So the question is it reasonable to search without a warrant? What if law enforcement only have probable cause, but they don't have a warrant? Is that a reasonable legal search? The answer to that question is yes. There are times when it's reasonable to waive the requirement for a search warrant as long as probable cause exists. A search without a warrant is what is known as a warrantless search, or a warrant, an exception to the need for a warrant. And these can be legal if within the scope of the exceptions that are outlined by the Supreme Court. So on the last slide, we're just going to do a quick overview of some of the exceptions. And if you have questions about them, text me, email me, or come to Zoom office hours. So here's a list of the times when law enforcement can engage in a search without a warrant. In other words, these are the exceptions to the warrant requirement. And so there are exigent circumstances as one exception: search incident to a valid arrest, automobile searches, consent searches, stop and frisks, which are really controversial these days, and many municipalities are no longer using stop and frisks, and in plain view searches. And so I'll talk a little bit about each of these, and then what I want you to keep in mind as you're reading in the textbook is, what's the reason for the warrant exception? Why are these instances, why in these instances are law enforcement able to search only with probable cause and not with a warrant? Keep in mind the scopes of these searches, and ask yourself yourself, do you think that these are reasonable searches? The court have all said that these are reasonable searches, but you might disagree with that. Exigent searches, or in exigent circumstances, law enforcement can search without a warrant. All they need is probable cause. And what an exigent circumstance is an emergency search, an emergency circumstance. And so, anytime, so for example, if somebody is in the middle of the road, they jump out of their car and they have a gun, and then they're just like, shooting at people. And then that individual runs off the road and runs into somebody's house or runs into their own house. Cops don't need to wait and get a search warrant. Lives are at risk. And so if there's an exigent circumstance, probable cause, they see this person with a gun who is shooting, running into a house, pretty confident that a crime has occurred, they can enter into that domicile or really into that any place without a search warrant, but based on probable cause. The reason that they allow this is because they want to allow police officers to prevent harm, and emergency situation harm is taking place at that very moment. It's sort of imminent. The scope of the search is that it needs to be based on an exigent or emergency circumstance. If there's no emergency circumstance and you just see somebody that you think is involved in drug dealing and walk into their house, or even if you see somebody doing a drug deal and walk into their house, that's not an emergency circumstance and you would need a warrant to enter that domicile. Search incident to a valid arrest. That's basically if you're arrested, you are allowed to be searched without a warrant. The arrest must be valid, and so if the arrest is not valid, the search isn't valid, and it's limited in scope. That an individual there can be a body search of an individual who's arrested and of their immediate, like a backpack or a purse that they might have, and also anything that's within their grabbing area of the person who's arrested. The reason for this is police safety, and that a person could have contraband, a knife, a gun on them, and so to wait for a search warrant, the person could get that gun and shoot law enforcement or anybody else in the vicinity. Automobile searches. Automobiles do get lower Fourth Amendment protections because automobiles are public. That, as we saw in Jones, it's not reasonable to think that what goes on in your car is private. So there's windows, you're on a public road, and also that because you're on a public road, you present a greater level of danger to others. And so the Supreme Court has allowed wide berth for automobile searches. You do need probable cause to search, but once you have probable cause, you don't need to wait to get to a warrant. So let's say cops pull you over, you unroll the window and a bunch of pot smoke comes out, or you unroll the window and they see that there's a gun on the seat next to you. At that point, you can be arrested, searched without a warrant. Consent search. We can waive our trial rights. We can waive our rights to counsel. There's a lot of rights we can waive. We can also waive our Fourth Amendment rights. So if cops ask you, hey, mind if I search your vehicle? Or mind if I pat you down? Or can I look in the trunk of your car? You'd be surprised how many people say, yeah, sure, go ahead, look in the trunk of my car. Oh, I forgot about the dead body. If you consent to a search, if you invite law enforcement into your home, let them search, you've waived your Fourth Amendment rights. You don't need a warrant for that. The limits to that kind of search is that the consent has to be voluntary. You can't be coerced into saying, yes, search my house. You can't beat a consent out of somebody. Law enforcement say, hey, they gave us consent. Okay. And also the consent, somebody has to be able to give consent. So a child, can't give consent. Hey, come on in, search my home. My dad is not home, right? You can't do that. A stop and frisk, that's where you let a law enforcement search people, not with probable cause, but with reasonable suspicion, because they happen to be in reasonably suspicious circumstances, and cops can do a pat down. Those are legal searches, but they're not being used very frequently anymore because they are seen to increase implicit bias and also conflict and danger for cops and for civilians. And then finally, in plain view, if during the course of a legal search, if cops see something in plain view, even though it's not part of the search warrant or they can seize it. So, for example, let's say that law enforcement enter into your house to conduct a search warrant, and the search warrant is to like search your desk or something like that, very limited. But then they walk in, you got a big pile of cocaine on your table. It's like, hey, it wasn't on search warrant, but it's in plain view and we can seize it. All right, so hopefully that didn't take too long. But if you have any questions about those are all deemed as reasonable searches. And so as you're learning about these, think about them as you learn more about them in the textbook. Thanks for your time. Sorry we went a little bit over here. And if you have any questions, please contact me. And again, thanks for your time and attention. I appreciate it. Talk to you again soon.